Hi, everyone. Good to be here. My name is Brian Smolak. I'm the Director of the Bureau of Labor Law Compliance. We are the agency within the Department of Labor and Industry charged with enforcement and education of the Pennsylvania Prevailing Wage Act. No small feat. In calendar year 2023, our Bureau received over 9,000 prevailing wage requests, one of our highest ever. Typically, it's between 7,000 and 8,000. So undoubtedly, as these broadband projects roll out, that would just increase our numbers. But we're here today to demystify prevailing wage, to provide for you common sense information on a high level, and absolutely get into some details if the questions take us there. The work that you will all be doing in some form, I know a lot of different folks are on this call with varied backgrounds, but it's noble work. It's to connect Pennsylvania, it's to connect people, to connect rural areas. So I applaud the work that you're doing. And our role is to not just enforce prevailing wage and ensure that workers are being paid correct and fair wages, but also to educate people to ensure that you're armed with enough information as to how to actually maneuver the process, to go through our website, to find the links that you need. And we're going to try to assist with that today and give you the information that we feel that would be helpful for you. So, and also with me, Chris Halleck, our Deputy Secretary for Safety and Labor Management Relations, and also on the call from our agency is Justin Romano from our Office of Chief Counsel. So, at some point, you might hear them speaking as well. There's Justin. Hi, thanks for being on here. And again, Chris, just interrupt at any point if it works. Sorry about that. Technical glitches always happen when we go live. All right. So today's presentation will focus on a number of topics. We've tried to gear this presentation based off of what we're hearing, based off of what we feel that all of you out there have been asking for. We get a number of phone calls and emails and correspondences that ask a lot about what is prevailing wage? How do I do this? What's a certified payroll? You know, a lot of those basics, and also some questions that get much more detailed. So today's program will involve just what prevailing wage is, the idea of public work, the idea of agencies putting money out there for the public's consumption to use that money in the form of construction costs. We're going to talk about wage rates and appeal processes, classifications for different work, workers on prevailing wage jobs, public financing, projects. I don't have to read all of this, but you can see we're also going to discuss exclusions from prevailing wage, things that don't count, things that don't merit prevailing wage rates to be applied. Then finally, we're going to talk about some other things, such as overtime on prevailing wage. There's a common question out there that we like to demystify as well. We will talk about some of our internal enforcement actions, the duties of contractors, subcontractors, awarding agencies. But to get a handle a bit on maybe the level we should start at, I would like to propose first a poll for those on this call. Feel free to join in. This poll is going to begin our presentation today by asking a very basic question. So when that pops up, you'll be able to take it. And I don't see it yet, but that's not because maybe my computer is not prepared. And there it is. Okay. What is the dollar threshold amount that requires prevailing wages to be paid in Pennsylvania? The options are $2,000, $25,000, or $75,000. And take your time. I'm not sure how quickly the results will be seen by me. Or do I? There we go. I'm seeing them. Okay, we have, this is fun. 25,000 leads so far. 2,000 and 75,000 are both tied for second with 51 responses, 55. We'll give another couple of seconds. This is pretty interesting to see. Okay. I don't want to create too much dead air. So as these responses come in, the correct answer is what's in green on your screen. For those who haven't taken the poll yet, I gave it away. $25,000 is the threshold. When we talk about a threshold, what does that mean? Well, in the next slide, we'll talk about it, but it's the dollar volume of the construction cost estimate along with the materials combined together to come up with that total project cost. Now, I see a lot of you, the second place finisher was $2,000. You're not wrong if you're talking about federally funded work. In this situation, we're talking about state projects, DCED grants that are going out for work that will be for state prevailing wages. So $25,000 is the correct amount. Thank you for taking this poll. There might be another one coming up soon, so pay attention. All right. So as we go to our next slide, what is Pennsylvania prevailing wage? Well, we just found out $25,000 is what leads to prevailing wage. We know that. But we also know that prevailing wage involves any construction, reconstruction, demolition, alteration, and repair work other than maintenance. Maintenance being the limited exception that we'll speak about on a future slide. Also, prevailing wage, to make it be a state covered job, it's got to be done under contract. There must be a construction contract for the labor. It must be paid for in part or whole by public funds. And as mentioned before, $25,000 in estimated cost. One important thing to note about paid in part or full by public funds is extremely important. If you have a project that say is being funded for, maybe you're doing a large scale project that will cost you as a project owner $100,000, but you're only getting $15,000 in grant money. That project would still equal prevailing wage because paid for in part or whole by public funds. You can get a grant for the full 100,000. You could also get a grant for just 20,000. Either way, when we have a part of public dollars infused into that project, now we talk about prevailing wage rates being necessary and those rates being paid to workers necessary. And then finally, Pennsylvania prevailing wages are required for any public work, even if these were not in the bid specifications. Okay. That project thing that I think we as labor and industry would really hope today that we're going to accomplish is to try to, accidents will always happen. Mistakes may be made. What we're going to try to avoid are projects happening, and then a year from now, after the project is done, and you're going back to DCED for a reimbursement or the final payment of the grant, and we find out that rates were never applied for and that workers never got paid prevailing wage. That
Brian,
issue? Oh,
Brian,
yeah.
I think that I'm not sure what everyone is seeing, but your slides aren't moving. I think you might still be on slide 1.
That project. So you're not seeing slide 3 at all. That project right now, the heading for me says Pennsylvania Prevailing Wage Act. That project.
Someone that's watching, please state which slide you can see. You just want to make sure you're on the right slide.
Yeah, because I could reshare from a different screen if that does not work. We're still on slide 1.
So Steph, this is Brandon Peters. Yeah, it is still on slide 1.
That project, it's okay. We will rebound. Hold on. Let me do it this way. Now, the only problem with me, I'm going to share a screen as opposed to the slideshow, so I'm not going to be able to see the my screen anymore. But can someone please confirm that you're able to see the PowerPoint again with the words Pennsylvania Prevailing Wage Act on top? That project.
You're good to go, Brian. I can see it.
All right, perfect. Thank you very much, because that would have been really confusing for everyone. All right. So let me just refresh, because you weren't seeing the screen. I think it'll be helpful for me just to refresh this. Prevailing wages are required for, as we know, 25,000. Construction, reconstruction, demolition, alteration, work that's done under contract. And also I was mentioning that Pennsylvania prevailing wage is required for public work, even if those rates were not in the bid specs. And I had mentioned that we want to try to avoid future issues in which we don't have rates for a job and then the work takes place and that, so then we're really behind the 8 ball. Once again, thank you for alerting me to that. If there's any issues at all with the slideshow as we go, please absolutely interrupt me. Public financing. All right, let's talk about the first tenet of the 4-pronged test for prevailing wage. Payment of prevailing wages is unconditionally required if the work is financed in part or whole by public funds. As mentioned before, the example I gave is we had a smaller grant infused into a larger project. The grant itself is much less than 25,000, but the total project is 100. That still requires prevailing wages because we have funding in part or whole. And we have examples here. And by the way, this PowerPoint will absolutely be shared. And I'm not sure completely the mechanism for DCED to do so, but we'll make sure everyone gets this, because these examples are very helpful. Private developer receiving any public financing for commercial projects required to pay prevailing wages. The project's total cost, not the amount of public financing, is what determines whether prevailing wages are required. And then finally, the public body does not have to be a party to the contract under this financing. No. for many, many decades prior to a lot of grant funding, a lot of court opinions back from the late 20th century and early 21st, we had this idea that prevailing wages were school roofs or township buildings or perhaps new roadway construction. As things have evolved, a lot of grant funding from both the Office of Budget and DCED have come in, a lot of other state agencies as well. Those grant dollars, that infusion of public taxpayer dollars into a project is what now makes these projects just a little bit different. The rule book changes, the playbook changes, right? We're doing something different now when you infuse that $1 public financing into that private job. And then finally, prevailing wages may be required if a private entity is performing work on a public body's behalf, including acting as a public body's instrumentality or alter ego. So enforcement. All right. So let's talk about how this all now works, right? So we have the idea that prevailing wages will be required if we have construction, reconstruction, demolition. We know that 25,000 or more is in that project. We know it's being done under contract. Now what? Great question. And my plan today is to not just show you this PowerPoint, but to walk you through our website so you can find everything we're about to talk about. So Labor and Industry, which is the agency I work for, the Bureau of Labor Law Compliance, acting on behalf of the Secretary, we determine the prevailing wage rates for job classifications. And in simple, prevailing wage is the most commonly paid rate in a geographic location. When you look to the Prevailing Wage Act itself, just to get a little nuanced, I don't want to throw too much legality your way, but prevailing wages are determined by locality where the work takes place. That's important. It doesn't say the state where the work is at. It doesn't say the township. It doesn't say the county. This is the locality. That's why it's extremely important for anyone who wants rates from us not to just go to our website and check out what they might be, but to actually put a request in for prevailing wages. It's not really a project until you put the request in. The request, based off of the geographic location where the work will take place at, is now what bases us to give you the proper set of wage rates. The rates might be different in one part of Adams County than the other part of Adams County. There are multiple rates throughout the state in various counties that differ based off of the locality where the work is at. Labor and Industry also investigates complaints for alleged violations, and we'll touch on that at the end. We engage in routine inspections, and it sure sounds like we're going to have some fun going out into the wild rural areas of Pennsylvania to see some broadband work. We also render opinion coverage. By rendering opinion coverage, what does that mean? Let's demystify that. If you out there say to us, hey, Labor and Industry, we have this work, we have this grant funding, we have this plan for the project, we do or don't think prevailing wages apply. What do you think? We give you an opinion. That opinion that you get from us is actually something you can grieve. We'll talk about that too. But it's important to note that we give a lot of opinions all year long on various prevailing wage questions. And then finally, we prosecute any violations of the act. That's us. That's the bubble that Labor and Industry is in. Let's talk about public bodies now. Some of you out on this call may be from public bodies. Some of you might be from contractors or who knows where. Well, what do public bodies have to do? Well, they should be including Pennsylvania Prevailing Wage in bid specifications, right? They should be assuring that contractors and subcontractors are paying those rates. And then finally, there's a requirement for a submission of certified payrolls. But you might be wondering to yourself, if you're a broadband company, well, you're not a taxpayer-funded entity, you're right. But because of different decisions and court decisions and rules over time, any grant-funded work creates the need for you to actually request state prevailing wage rates, for you to collect these certified payrolls that will eventually get their way back to DCED, okay? So public bodies include, as we say here, typically Commonwealth government agencies, any authority created by the General Assembly, Commonwealth instrumentality, Penn State, state-related universities, political subdivisions. We list down cities, counties, boroughs. But for this audience today, what's important and what's distinct and special is that grant-funded work creates a different sort of category. Prevailing wage rates in Pennsylvania are determined by the actual work performed based on the worker's job classifications, as mentioned before, in the locality or county of the work being performed. We have county in parentheses because we can often look to the county. But if we get specialized rates from somewhere out there, about a locality having a different rate in a certain county, you would add those rates into the actual project determination. And that's why it becomes urgently important that someone requests rates from us. That way you have in your hand the correct wage rates instead of making an assumption that they're right. Classifications are based off of custom and usage in the construction industry in the county, or sort of this type or locality, right, where the work is being performed. The rates are based off of typically collective bargaining agreements or other data for the craft and classification for where the work is being performed. The state prevailing wage rates may include the rate itself. There's a fringe benefits section, and there's also notes that we can actually refer to you. My plan is at the end of this presentation to go through from that link there, show you how to actually get and maneuver our website to find what you need. And then finally, payment of wages by lump sum or piece rate violates the Prevailing Wage Act. That's just a little factoid to remember. There are different types of prevailing wage determinations that our department will make. A building determination, a highway, a heavy, or a residential determination. They're the 4 common types. Now, for most people on this call today, you're not going to worry much about that building or that residential classification. A building classification is kind of what it sounds like. It's a construction in a sheltered enclosure, right, with walk-in for housing, equipment, supplies. You think to yourself something that's habitable, apartment complexes, state buildings, things like that. And residential buildings are typically detached single-family homes, or a unit within a duplex or a single townhouse. And even heavy jobs, well, heavy jobs might be involved here because depending on what these grants will entail, you might very well be doing antenna towers, right? You might very well have someone involved needing pipeline installation, sewage installation, if there's a need to move sewage lines. I don't know. Every project will have its own distinct amount of work associated with it. But a lot of what we're going to find for the work you're doing is highway work. Highway being the construction, alteration of roads, streets, highways, taxiways, alleys, paths, parks, parking areas, other projects not incidental to building or highway into building construction. So if we have lines being installed outside of a home, going into a building, there will be inside building electrical work. It's my understanding that the vast amount of work being performed for this broadband work will be outside, in fields, in grassy areas, in mountainous terrain. Things that will be outside work will be considered highway rates. When you get wage rates from us, and I'll show you this, I'll show you where to find the rates that you need to look for. All right, how do we issue prevailing wage rates? So I will say this, oftentimes government is bureaucratic. There's a lot of paperwork. There's a lot of red tape. This is something that I believe labor and industry gets right all the time. There might be accidents, there might be mistakes, right? Happy mistakes if you're a painter fan of Bob Ross. But in general, what we do is when we receive a wage rate determination, we get that determination back to the person who requested it, either the same day or the day after. If you don't get wage rates back on Friday afternoon, most likely you'll get them Monday morning. If it takes an extra day, perhaps the person who did it was at meetings or out sick that day. But typically our turnaround time is less than 48 hours, which I think serves you out there very greatly. I believe that wage rate turnaround is really, really good because you need to have a good working knowledge of what the wage rates are. A lot of times construction is fast. We need to get bids. You have the need to put something out for bid really quickly if there's an emergency project. So this is something that we get within 48 hours. If you do not receive a wage rate determination after 2 or 3 days, one of 2 things happen. Number one, it might be due to us just being behind. Maybe a lot came in, but it's more likely that the wrong email was put in there. And if that's the case, we have ways that we can get those wage rate determinations for you. But oftentimes, if there's a little spelling mistake, if you forget the h&smith@whatever.com, you may not get your wage rates back because it went to an undeliverable address. So make sure when you're asking for wage rates to look it over 2 times to make sure that that information is correct, or there may be a delay in getting rates back to you. These rates, by the way, should be done before the project's out for bid. The reason being is because the Pennsylvania Prevailing Wage rates should be contained in any bid specifications for the contracts for a public work job. That way there's no mystery. If you're a plumber, if you're an electric lineman, if you're a laborer, you contractors bidding on the work, they get their wage rates in hand. They see right here on paper, oh, as of May 1st, 2024, this is what I pay a laborer. This is what I pay a whatever, right? So it's important to get these rate determinations from us and make sure it's in your bid specifications. There can be challenges to these rates. So let's briefly go through what these rate challenges might entail. An interested party defined by the Prevailing Wage Act may file a petition and seek a hearing challenging a wage rate determination within 10 days from the publication and issuance of that rate from us. A lot of times these happen because of mistakes. Remember I mentioned before, there could be multiple wage rates in a certain county. We might get it wrong. We might be off a few miles. Maybe the stream that we found on a map was not really what we thought it was, and we give the wrong rate. Many times we have to modify those rates if someone will contact us within 10 days and say, hey, labor and industry, you goofed up. You have the wrong rate on there. A different type of challenge could be a party basically saying the prevailing wage rate has evidentiary and legal burden of establishing the party challenging, has the evidentiary and legal burden of establishing the alternative rates at an expedited hearing. And then finally, hearing decisions may be appealed to the Pennsylvania Prevailing Wage Appeals Board. So let's go back to this for 1 second. Hold on. The challenges are in the act itself. And if you want to read anything further about it, Section 8 is where you can find that. The challenge, who's entitled to prevailing wages? All right. So people who work on a job, right? A worker includes by definition a laborer, a mechanic, a skilled and semi-skilled laborer, and apprentices employed by any contractor or subcontractor engaged in the performance of duties. So let's break this down. Let's say an entity puts a contract out. Now we have the need to install broadband communication wires somewhere in Franklin County. The bid goes to Smith Incorporated, and Smith will now sub out certain types of work to different contractors. Maybe Smith 2 does this, Smith 3 does that. The challenge, any workers on that project, any people who do labor on the job, anyone who picks up the tools of the trade, you are now entitled to prevailing wages for the work that you do. That work, by the way, could be involving things that you might do if you're a foreman and you're just a supervisor, but you pick up a tool this week because you have a shortage of staff and you got to get the work done. You're now entitled to prevailing wages despite the fact that maybe last week as a supervisor you weren't. Once you pick those tools up, once you do work in that job, you're entitled to prevailing wages. We mentioned on here examples of work, and I want to touch on apprenticeship in a moment. But let me first go further beyond that. Any workers performing testing and balancing of alarm, cable, other systems, that's covered by prevailing wage. Surveyors, truck drivers hauling materials around the job site from an adjacent borough pit to the job site. Oftentimes truck driving is very specific. If you have questions concerning truck drivers doing work on your specific projects, you will want to contact us so we can talk about your specific scenario. And then finally, individuals engaged on on-site engineering, testing, or inspection work on public works during construction, which is an integral part of the construction process, that would also be covered work. We get a lot of questions about the very first bullet point, apprenticeship and training. And what does that mean? So a lot of companies have training programs. A lot of companies have probationary periods. Perhaps you pay workers a little less for the first 6 months and then they graduate up as they get more experience. When you're on a prevailing wage job, those side agreements you might have don't really matter now. If you have a worker who's performing as a laborer, as a carpenter, as a plumber, as an electric lineman, the rate that we give on our rate determination is what they must receive, regardless of experience, regardless of how long you've employed them. What gives you the ability to possibly pay less as a percentage would be if you have a registered state-approved apprenticeship program. When we say state-approved, we have a council in Pennsylvania. The State Apprenticeship Council reviews programs. We see what the department council sees what education components are involved, what training components, and if they agree that it's a great program, they approve it. If it's not approved, or if there's no official apprenticeship program, if we see apprentice wage rates on a certified payroll, but there's no program, That will be a violation if there's an underpayment. I want to repeat, apprenticeship is very official. We can't just call someone in training an apprentice unless they're a registered, bona fide apprentice, registered with the State Apprenticeship and Training Council. Please keep that in mind. Avoid violations, avoid mistakes. What is a project? So this is something to go back to the 25,000 threshold. Let's start there, right? A project is 25,000 or more in estimated cost. And it can't be divided into separate projects to fall below that threshold. So if we may have different work happening on the same project, but we say, well, we believe that this is 4 different projects because it's 4 different, types of work. Not really, right? To avoid prevailing wage by dividing it up would be improper. And we often will make determinations that it is improper. However, if there's anyone out there who feels that there is a logical and strong difference between one phase of work and another, email us a letter, email us a question, and we'll look into it. But typically, a project should not be getting divided up just to get projects below 25,000. Pennsylvania prevailing wages may govern a stage or stages of multi-phase construction that constitute separate projects. So mentioning before, if you feel that there are different phases which equate to what's commonly called out there a quote logical demarcation, if you feel that's the case, send us a letter asking. We will review that and we'll determine if we agree or not. And then finally, as mentioned here, the Bureau of Labor Law Compliance reviews these projects often for Pennsylvania prevailing wage requirements. Opinions and grievances. So we, as mentioned before, give a lot of opinions. Upon request, the Bureau of Labor Law Compliance will issue opinion letters on prevailing wage coverage and requirements and anything associated with prevailing wage issues. Those issues typically include whether a project is actually public work, whether it should be excluded as some sort of a maintenance project that's not public work, or whether, as mentioned on the previous slide, there's separate projects that are happening. We'll give an opinion on that. We'll say what we think, and we'll respond to you within, in my opinion, a very adequate, good amount of time, so you have a fast turnaround. Unless there's a need for us to get a lot more information from you, these are typically not long processes. If you get this opinion, don't like it, or if someone else doesn't like it, any interested party can file a grievance with the Pennsylvania Prevailing Wage Appeals Board, seeking review of the position that the Bureau has written. The board also reviews what's called Section 8 wage or Section 8 rate proceedings and adjudications and violations. This 7-member board is comprised of an attorney who represents L&I, a public rep, a public body representative, union reps, contractors associations. And then finally, board procedures and forms are all contained in the PA code. So it's important. There's the Section 8 issue, and this slide will give you the ability to grieve or ask opinions. So keep in mind that when we issue opinions, any interested party to that opinion could grieve. We mentioned about exclusions. So yes, let's go back. I remember when we did our first poll, a number of people said $2,000 was the threshold for prevailing wage. And I mentioned if we're talking about federal Davis-Bacon, you're right, 2,000. We're talking about state prevailing wage today. Maintenance work is an exclusion. We'll be discussing that in a moment. And then work performed under a rehab or manpower training program. Let's also mention too, grants pertaining to the use of acquisition of equipment or for job training. That's not going to require prevailing wage. For a grant to require prevailing wage, we have to talk about 4-prong test, $25,000 or more in work, done under contract, and actual construction work, reconstruction, demolition, not maintenance. There's some more exclusions. Construction financed by tax abatements. This exception does not apply if the language specifically creating the tax abatement requires the payment of prevailing wages, however. Off-site work. What does off-site work mean? So while this may be not the greatest example for the audience on this call today, it's an example that I think you could sort of common sense use. If you're building a modular home somewhere in Washington State, right, and the modular home is being shipped to Pennsylvania fully done, And when it gets to Pennsylvania, a grant is paying for the modular home to be installed with plumbing, with electric, with carpentry here. What's covered? Not the building off site. The work done there is not covered. The installation of that home, the work done on the real property in Pennsylvania, that is covered. So the off-site work, I use that as an example. Again, you may have other examples that you would like to ask us about, and many times they're going to be case-by-case type things. So we would absolutely talk to you about any questions that you have on that. Material suppliers who do not perform work on a project, they would not be covered by prevailing wage. Remember, tools of the trade, you install, you do real work on that project. Public body employees, no requirements for prevailing wage. Great example. We have a new electric lines being put into the labor and industry building, and a lot of the work can be done by state employees. Those state employees will not get prevailing wage, but the work done under contract will. So state employees can't do everything. The work that can't be done by a DGS employee would be put out for bid under contract. Now the contract that's in place, and if it's more than 25,000, we have new work happening, the contract work would get prevailing wage. Furniture assembly, if the furniture is not installed, there's a desk right there that kind of shows the chair may not be covered, but that desk might be if we're installing it, right? I don't think anyone on this call will be installing equipment in an office, but that's the example we have for sort of the practicality of that. And then finally, supervisors performing work if they don't use tools. That's extremely important. Again, working foreman, someone who is a real supervisor, who does not work on that project, who just tells people what to do, that's not going to be covered by prevailing wage. That person's work is not covered until they work for 5 hours today in the trench. They install electric lines, they put in conduit. If they do that, that work done needs to be on a certified payroll and paid the proper rate for the work that's happening. Maintenance work. All right. So maintenance is a very narrow exception to prevailing wages. Typically, maintenance is the repair of an existing facility when the size, type, or extent of the facility is not changed, right? My thought about this, and we have mentioned here the idea of a pothole. We have a picture right there of a pothole being filled. If that's it, if that's the amount of work that's being done, it's probably not going to be covered work unless there's some other components to the work. But I think for the purposes of today's call and today's presentation, this will not be what we're doing. So it's important to make this distinction. Maintenance is narrow. Do not assume that you're doing a maintenance project. As mentioned before, if we see an apprentice on a job, but there's no apprentices registered, there's a problem. If someone makes a determination that a project was maintenance, but we don't agree with that, that could also be a problem. So the best thing to do, best course of action would be come to the Department of Labor and Industry, and we will give an opinion to you if we feel that something is truly maintenance or not. That's one of our common opinions that we give out. Okay, not maintenance work. This is what requires prevailing wage. Any reconstruction and replacement that is not that is in kind and not excluded as maintenance requires prevailing wages, right? So let's go down to those bullet point listings there. Sidewalk replacement is not maintenance. Telecommunication wiring using existing conduits, not maintenance. Roof replacements, not sure if you're going to worry about that, but road milling and replacement, that might be something that you'll be doing. That's not maintenance. Any repair or rehabilitation of manholes, not maintenance. And finally, painting other than covering up minor imperfections, not maintenance. You can't see the wall behind me, but if you could, there's a background that makes me look like a talk show host behind me. But if you could see my wall, there's a few little nicks taken out of the drywall, just little pieces here and there that bothers me. But if I ever repair that, well, number one, I'm in a house, so it's not going to be prevailing wages. But the theory would be those little nicks, those little deviations. If I just repair those, it's probably maintenance. If I repaint the entire wall, that's not maintenance. That is now reconstruction. Be happy you can't see my wall. All right. Public body duties. So the public body or the grant recipient in this situation, I believe that we're talking about grant recipients, right? There should be a request for prevailing wage rates for the project from the Bureau. And this is important to note. When we give rates out, if you put a request in today for a rate determination, we're most likely going to give that rate determination out to you today, February the 7th. Had to check my date. So that rate determination is good for 120 days. What does that mean? Well, if you put out that bid and someone bids on the work now and the contract gets awarded March 1st and the work starts April 1st, you now have a set of wage rates that is good for the entire duration of your project. The rates that we give out are good. You put this out for bid and a contract was awarded within 120 days. That's fine. But here's an example of when you have to make a new determination. You put in a wage determination today, construction delays happen. This happened a lot during COVID. We had situations where projects were set to begin, never did, and then a year later were put out for bid again. That's well beyond 120 days. Therefore, the awarding agency or grant recipient should be putting in a new request for prevailing wage. What we do is we would then, I don't use the word delete, we will archive the request currently there, replace it with the new one, and you will have a new set of prevailing wage rates for the work that will take place. And then we say here, submit the prevailing wage awarding agency form within 5 days to the date of the contracts awarded. So there's a little requirement in the act that an awarding agency should be submitting a form to us within 5 days. And that form will just give a listing of the contractor and subcontractors that got work. And you can find that also on our website. More public body duties, including possibly, hold on. Can we go to our next poll by any chance? And I'll have to go back to my screen to see this. And I'm sorry you're seeing two of me, but I want to see the poll as it's put up here. All right. Next question for everyone. Who is required to fill out certified payroll forms? Options: labor and industry, DCED, construction contractors, or construction workers. And I guess if I take the poll, you'll see the answer. So I'm going to pick the wrong answer to give you some help. All right, let's see. Construction contractors. My response is DCD. I already gave you the hint that's wrong. Labor and industry, we have 6%. And we have construction workers so far at 0%. All right, let's just give it another couple seconds. 7% for DCD. 7% for L&I. Very interesting. Okay. Can we change votes? Because I saw the percentage. I guess more people voted. All right. Fun experiment. The folks who answered labor and industry are wrong. The folks who answered DCD, like me, wrong. And no one answered construction workers, which is good. The correct answer is construction contractors. That is who is required to fill out Pennsylvania prevailing wages. So the public body, or in this case, the grant recipient, right? They should be placing the prevailing wages into the bid specifications for the public works job. They should be incorporating the Pennsylvania prevailing wage rates that we issue for this work. And they should enforce the posting of these wage rates, right? Workers should be aware of the fact that this is prevailing wage. They should know in the job trailer, the rates should be hung up. There should be no mystery behind what the rates are. They're set by law, they're set by the department. There's no negotiating on the wage rates. And then finally, the requirement of a weekly filing of certified payroll form should be collected from the contractors and subcontractors. So not a poll question. I wish we had this. Who's required to fill out prevailing wage certified payrolls? Any contractor or subcontractor on the job. As mentioned before, if you have the work being subbed out to 5 different subcontractors and each subcontractor has 2 or 3 employees, there should be 5 different certified payrolls for that week for all the contractors and subs in that work. And that should get back into the hands of the awarding agency or the grant recipient, and then eventually DCD would review, and labor and industry might review too if we have any discrepancies or questions with anything. We would also ask that the awarding agency or grant recipient contact us if you find out that there might be an underpayment of prevailing wage. We can try to step in. Instead of having a project go on for 6 months to a year of the wrong rate, maybe we could just nip it in the bud where it's just a week or two, right? Avoid issues. Might be a mistake. Maybe you looked at the wrong line. Maybe you missed an escalator, which means the rate goes up on a certain date. There might be some unintentional reasons behind it, but it might be better for us and more beneficial to contractors that we take care of that early so it doesn't become a festering problem. There is a certified payroll form in all its glory. Now, it looks bureaucratic. It looks like it's difficult to fill out, but it's not. And I will show you at the end maybe a better version of the certified payroll form. But contractors and subs must file this on a weekly basis with the public body or the grant recipient. The certified payroll should contain all the workers who are on that job site, the work classification of what they're doing, the days they're on that job, their rate, their fringe benefit, the deductions from their paycheck, and then finally the gross pay for prevailing wage jobs, along with the check number of the money that was issued to the worker. Certified records filed with the public body are actually open for public record and inspection under the right to know law. Contractor and subcontractor duties. So we have their pay prevailing wages. I think the theme of today is prevailing wage rates, and we all know that we're here because there's an unconditional duty to pay prevailing wages, except as mentioned, for the small exceptions to prevailing wage work. There's mandatory postings. So again, back to what I said before, rates should be posted on the job site, an accessible location, a break room, the job trailer, somewhere where people punch in, punch out. I understand that the work that will be performed in this situation might be in some wilderness areas and some mountainous terrain. I get that. But common sense would be there should still be a centralized location that workers can view these prevailing wage rates, and that's where they should be posted. And then the posting shall contain the information listed in our regulations. We will also show you here in a moment or two when I'm done this, the notes of where you can find notes for different wage determinations with our state as well. Some more contractor and subcontractor duties. Records. All right. Keep records, right? This record keeping requirement, it's not just for prevailing wages, because we have this idea of certified payrolls, right? The idea of the certified payroll is certifying that the taxpayer dollars that you're getting in some form or another is going to the workers in this form, in the form of rate and fringe benefits to the worker for the work performed. That's the duty of the contractor and the subcontractor. And again, the form being used is a certified payroll form, which is completed weekly, and falsification of those forms may be prosecuted as a criminal offense. So these forms are important. They detail out what's happening with this public money, the money that the state's giving you. Where is it going? Some of it might be going for materials, but when it's going to the workers, the certified payroll form under the law, that you're not falsifying it, is saying what you're paying each worker on a job site for the days and times that they're on that job site. Keep these for 2 years. Now, there might be some additional requirements under additional laws, such as maybe the IRS makes you keep things longer. Maybe some other wage laws makes you keep things longer. But these certified payroll forms, 2 years is the requirement. All right. Fringe benefits. So we get a lot of questions about fringe benefits and what they are. So it might be the easiest thing for me to explain it like this. If we give a wage determination out to you, and you look at the category for, let's say, a laborer, and the labor rate is, let's say, $40 an hour for the actual wage, but then you see a category for $10 an hour for a fringe benefit. What does that mean, right? What does a fringe benefit mean? What a fringe benefit consists of is things that you're paying already on behalf of the worker. Perhaps the worker has a bona fide health care plan. Maybe there's vacation days, sick days, maybe some travel expenses, maybe retirement, pension, 401k, things that you're paying in on a quarterly basis, right? A 401k program or the health benefits, and you're paying a certain dollar amount per year for that worker. You can credit that wage rate. You can credit yourself because now you're saying, well, heck, $40 an hour, but $10 fringe benefit. I probably can claim vacation. I give my workers vacation. I give my workers health care. You can claim that as a part of the fringe benefit, not for the money that they as a worker pay in, but for what you as a contractor pay for the plan. Now, one of the common violations that we see, so avoid this one, is that a lot of folks think, well, the fringe benefit means I just don't pay that. I just pay the 40 an hour and I let the $10 go. No. If you do not have any vacation, if you don't have any health plans, if you have no 401k, you're not breaking the law by not having those. But if you don't have those, you can't claim the fringe benefit. The only way you can claim the fringe benefit would be if you actually give people health insurance or the other things mentioned. So back to my example, the rate's 40 an hour, the fringe is 10. If you don't have any benefit plans, now you must pay the worker $50 per hour. It's only that you get that forgiveness when you can credit the wage rate full total package because you actually gave workers fringe benefits. A little confusing, but I don't think it's as confusing as some people make it out. Always remember, a fringe benefit is a benefit for the workers, typically the health plan, the 401k plan, the vacation days, and you cannot claim a credit for what the worker pays in, only for what you as a contractor or an employer pay on their behalf. We're going to go over some different remedies that happen. So I'm going to not focus too much on this because I want to get into the education from our website to show you that. We have different violations that we can find, right? There might be some unintentional violations out there. If we inspect a job site or if we get complaints from workers, there may have been an underpayment, but it could have been a mistake. It could have been that perhaps you missed an escalator. Those might be unintentional. We also have, however, let me just skip ahead for a second, the idea of intentional violations. These are more egregious and more serious. If we find, and I'm just going to mention it in brief, we don't want to focus on this, but if we find that any contractors out there are purposely violating the act, knowingly underpaying workers, we're going to look at that different, right? We have to keep the playing ground fair for all contractors. These types of examples of violations are more, if they're intentional, there could be a possibility of even a debarment for many state contracts. So we treat purposeful and willing violations of prevailing wage very seriously. Let me jump back real quick. A couple other laws that we talk about. The idea of an authorized deduction. Now, you're not going to find anything in our Prevailing Wage Act about authorized deductions, which means, in essence, money that you're taking from an employee's paycheck. But keep in mind, there's a wage payment and collection law that addresses this. An authorized deduction in Pennsylvania is comprised of two things to make it permissible legally. Number one, any deduction from the worker's wages of wages that you're taking from that worker must benefit the worker. And number two, they must authorize it in writing. If those two things are not met, we may have an issue under the wage payment law where we can find a potential violation. Again, not prevailing wage, but it's worthwhile to mention that when you take money out of a worker's money, there must be a signed authorization and it must benefit them. Court order, child support, things like that. We're not talking about that. Tax garnishments, we're not talking about that. We're talking about money that you're willingly taking from the worker. Maybe they're co-paying on a healthcare plan, co-paying in a 401k. They sign an authorization that benefits them. That's fine. That's valid. It's money that you're taking out for, they wrecked the company truck. They lost their uniform. We're going to deduct money from your paycheck. That's the violation. Unauthorized deductions also could include per diem payments, motel room expenses, tool rentals, safety fines. You're fining someone because they maybe didn't follow an OSHA requirement. Not saying that they should not follow an OSHA requirement. They absolutely should. But when you're taking money from their paycheck as a punishment method, that violates the wage payment and collection law. It would be your company's discretion to come up with some other form of a discipline program. And then finally, deductions not authorizing worker authorization, as mentioned before, garnishments for administrative fees, the pension administrative fee, amounts that are complying with court orders that you've received from a law enforcement agency, from a court, or maybe from the IRS for a tax lien. Very common question we get is overtime. And we get the question, hey, what does the prevailing wage law have for an overtime requirement? And our answer is always fun. We say nothing. Pennsylvania Prevailing Wage has no overtime requirement, but there still is an overtime requirement. The Pennsylvania Minimum Wage Act, which is a different law enforced by Labor and Industry, that requires payment of time and a half on the hourly base rate for any work that exceeds 40 hours per work week. Time and a half is pretty simple. It's a mathematical calculation. But let me bring you back for a moment to what I mentioned before. Remember I mentioned to you that the fringe benefit allows you to take a credit. If we have that $40 per hour example and the $10 fringe benefit example, let's say you have no fringe benefit program, and now you're paying worker in his or her pocket $50 per hour. And now they work overtime. You have a bigger overtime liability because now it's time and a half on 50, because it's whatever the hourly rate that you're giving the worker that constitute as the established rate for the time and a half calculation. Okay. Again, that is not found in prevailing wages. Another question we get, if someone works over 8 hours a day, is that overtime? Not by law. Could if you want to, but the law requires that you would give time and a half if someone works more than 40 hours within a 7-day period of time as defined by your company work week. Okay, we mentioned unintentional and intentionals. We mentioned intentional violations treated seriously, and that does include a debarment, repayment to workers, and possibly termination of public contracts. So we don't want to see debarments. It's a lot of work for our legal counsel, but we have to do this at times for anyone that intentionally violates the act. There's also proceedings. There's an administrative hearing proceeding. There's worker protests that can be filed. If a worker doesn't feel that he or she is receiving the correct rate for the work being performed, they can file a protest, and we in turn have investigators that look into those potential violations. All right, that's our website. We have 5 district offices: Altoona, Harrisburg, Philadelphia, Pittsburgh, and Scranton. I will not tell you my favorite. And then finally, we're done, but we're not done. I want to show you now, and please someone tell me if you can still see my screen. I hope you can. I have our website up right now.
Brian, I only see you.
You only see me. Well, that's not good. Let me try this again. Now you should see my screen. I hope.
Yes. We can see your screen.
We should have had a poll question, which was better, my screen or me. All right. So here's our website. And let me first give you the caveat. Unfortunately, what you're seeing here may not be the way it looks at some point in the future, because all of the state websites are going through a pretty massive overhaul. However, I think it's going to be even easier than it is now. So let's be faithful that it might be a little bit clunky and difficult to find things, but we're going to try to make it even easier. But as of now, for anyone who wants information about prevailing wage, 2 options. You can go to this little magnifying glass and type in here when it pops up. Well, search bar should pop up saying prevailing wage. For me, it's not, but for you, hopefully it will. So you can type in prevailing wages, but here's a different way to do stuff. Go to the services tab, scroll down, and a lot of different things you may want to look at. Boy, don't you love that. Remember when Steve Cook unveiled the Apple phone and it didn't work? All right, let's try this again. Let's go back to the main page. It's almost like this was planned to fail, right? The DNS lookup fail. Oh my. All right, while this loads, I don't want to have too much, again, dead air. I'm going to, I hope at some point here, be able to show you all the things that you need to see on our website. I will continue trying to get this to work, and I will reshare that screen when it finally does work. But at this point, that was my presentation. I hope that it helped. I hope it answered some questions, and feel free to ask questions now. There's a chat feature on the side of your panel, and you could absolutely ask questions. And Chris, I see you again. Does your audio work?
I tried calling in. Can you hear me?
There we go. You're good. Yes.
Okay. I did want to just jump in everyone and say, first of all, Stephanie, Brandon, our friends at DCED, thank you very much for allowing us this platform to reach out. My name is Chris Halleck, as Brian said at the beginning. I'm sorry for the technical issues. I'm not sure what it was. Obviously, we're having quite a few today, so it's just one of those days. I can assure you that the website does work whenever you go to it, but something with Brian, unfortunately. Lydia, I'm sorry for the problems I was having initially, but I did want to say thank you for this platform. You know, here at Labor Industry, we value and take just as seriously our ability to conduct outreach and to educate people and try to ensure that people comply with the law on the front end instead of having to take enforcement actions. So just know that we're here as a resource. We want to help people to accept their questions. We know this is a confusing space. Hopefully you found Brian's presentation informative. I know we're going to take some questions now at this point, but I wanted to pop in and say thank you for this platform. And again, I'm sorry for the technical difficulties I was having at the beginning. So thank you.
Yeah, and I believe that it looks like we may have a complete no PA websites are working at the moment. So, you know, perfect timing for this presentation. But anyway.
Brian, this is Stephanie. I will be queuing your questions. We will be reading them to you so that you can focus on the question at hand and not the chat. Your first question is from Julia Kaler from Breezeline. If the ISP is considered the subrecipient, should the contractor submit their certified payrolls to us for compliance reporting under BEAD?
Yeah, so there might be some technicalities with BEAD or the word subrecipients, but I'll use the words this way. Yes, if you are a grant recipient and the work is being performed on your property and it's being done under contract, those contractors are going to be submitting the certified payrolls to you. So in that circumstance, yes, you would be the collector of the certified payrolls. And Steph and Brandon, I'm not sure if you want to speak to this or not trying to put you on the spot, as far as the certified payroll requirement, like to be eventually in your possession somehow. I don't know if that's at this point ready to go, but theoretically what happens here is the certified payroll forms are on file eventually with DCED, but you're collecting them on a weekly basis from the contractors and subcontractors.
Brian, thanks for that question. It is yet to be determined.
Okay.
Once everything's approved, then we'll have more logistics.
Very good. So the big message would be collect them, make sure you're doing it, and make sure that it's being done on a weekly basis.
I'm going to go, Brian, I'm going to go back to one of the earlier in the chat when you were going through slides. There was a question on the slide about which workers are entitled to prevailing wages. And someone asked specifically if traffic control service providers are considered workers that would be entitled to prevailing wage.
That's right. If our website was working right now, I can show you the laborers notes, which are on our website. So there's a lot of notes on our website. And let me sort of briefly explain without having the website to kind of help me. On our website, under the prevailing wage section, we have different notes established for operating engineers, for painters, for laborers, for electric linemen, for, I think, asbestos workers and truck drivers. Those notes that we give have strange names. They're called the 29 county notes or the 33 county notes or the 5 county notes. What does that mean? When you click on the note itself, you can see which counties are included. So typically the 29 county is the northeastern part of the state down to the central part of the state, maybe the Harrisburg-Dauphin County area down to York and Lancaster. The 5 county, well, that's the Philadelphia County. And then finally, the 33 county is typically the counties west of the Susquehanna River. Each note would actually detail out certain tools. For example, operating engineers might use certain tools. Maybe they're using the vac truck on a job. That could be an operator 1. You would also have the electric lineman tasks, which are sort of detailed out as to what the lineman tasks would be. And then finally, the question on flagging. Yes, that is a laborer task under our laborers notes for the highway section. Great question. Really wish I can show you this. So maybe by the end, we will have this work.
Thanks, Brian.
All right, and another one for you. This came from William Newberg. Question is, suppose a project encompasses multiple prevailing wage localities. How is that addressed, and would we have to break it down by each area or use an average?
Yeah, wonderful question. So what I'm going to try to show you, again, our website's not working. All right. What we would do, okay, if we have a multiple set of locations. So for example, let's say the work that you're doing, and this happens a lot with school buildings if you have various schools in a certain county for one district, or it happens a lot for the turnpike. There might be a turnpike job that encompasses multiple counties. We would typically ask for you to contact us, give us the locations where the work is at. If there's multiple counties or multiple locations in one county, but we look at that county and say, you're good. There's only one rate for all this work in this county. Just do one request. But if we instead say, well, we have here's the localities where the work is at. We have 3 potential wage rates. We would actually ask you to do 3 prevailing wage determinations from us for each location. It's important to note, again, the locality where the work is at is what the law requires here. It's not our choice on this one. It's just what the law states. Great question. So we would ask you typically, if you have a multi-county project, give us a call, and there might be the need to do different wage requests for the different counties, and there might be different rates in different counties or within the same county for that work. Great question.
Thank you, Brian. Your next question is from Cheryl. Do we just call into any other offices to request a correct prevailing wage rate for a specific locality?
No. So what we would have you do is an official wage rate determination form on our website, which is not working. I was going to show you this. I should have screenshotted everything. I'm sorry about that. I should have thought ahead of this potential. On our website, under the prevailing wage section, again, there's a section on there called an application for prevailing wage. There's 2 different options when you click in there. One is to view prevailing wage rates. The other is to apply for prevailing wage rates. So it's not by calling our offices. Don't do it that way. Do it on our website. And if you want to do the old-fashioned way, we still have a paper PDF form if you want to send it by mail or fax, but don't do that because it will take too long. The website online form is automatic. You will get a copy of what you submitted to us immediately. And then again, within a day or 2, you will get the wage rates back to your email that you put in there. So remember, if you want someone different to get the rates and not you, put their email in there, because whatever email address you put into this online form, that will be who receives back the prevailing wage rates.
All right, Brian, is there work being done to classify telecommunications linemen differently? Right now, the only classification is for electrical linemen, which is a distinct role from electric linemen in industry. Thus far, though, no such distinction exists according to Department of Labor and Industry.
Yep, so our lineman notes address the type of work that the department feels that a lineman work should be. We also have a potential for the work on a project to not just be a lineman. There could be an operating engineer. You mentioned before flaggers. A flagger would not get a lineman rate. A flagger would get a laborer rate. There might be people digging trenches with shovels, not using any equipment for the line project. That could be a laborer rate. So just because we have a lineman rate for the majority of the work as far as the installation of conduit, et cetera, there could be other classifications on the job site as well. So that's the important distinction. My advice at this point would be to review our lineman notes on our website when it works. And then again, back to the review of our PowerPoint today, there's different things in there concerning potential legal processes if you felt that there should be something different.
Thank you, Brian. Our next question is very similar. Is there a classification specifically for telecommunication workers versus electrical workers? And I think you answered that.
Yes.
The next question, do you use straight overtime on the hours at the time they go into overtime, or weighted average for both prevailing wage and non-prevailing wage work?
Wonderful question. And don't you love the answer? It's up to you, but I'm not going to say completely up to you. That's a kind of nuanced question, but I think it's important to kind of flesh this out. We could have a situation where the weighted average, basically for those who maybe don't know, a lot of payroll folks out there may know, the weighted average kind of averages the different rates of pay together, dividing it by the total number of hours worked to come up with the halftime rate. Because in theory, you paid everyone the rate, you just didn't pay the half that's additional. So the weighted average allows you to have a mathematical calculation to do like an average of all those rates. That's fine. That's permissible. Federal law allows it, and Pennsylvania law would allow it as well. You also can do what's called a rate in effect. And rate in effect means it's your company policy that whatever the work that's being performed at hour number 40 and beyond, The overtime is based off of that work being performed. What we would say, however, and this is a very important thing, while there's the ability to do either the rate in effect or that weighted average, you can't change it every week, right? So if you decide, well, it might be in our economic interest to be the weighted average this week and maybe rate in effect next week, or no, it's whatever your company policy dictates, stick to your company policy. But in that really great question from, I think, Patricia, it could be the weighted average or it could be the rate that's in effect at that time. Great question.
Thanks, Brian. Is there a way that compliance with federal DBA could encompass the state compliance? I think that they are referring to the Davis-Bacon. Is there a way that could encompass state compliance?
I mean, in general, these are state projects. It's my understanding that Davis-Bacon rates do not hold on this type of work, and this would all be subject to the Pennsylvania Prevailing Wage Act. So at this point, I would say follow the Pennsylvania Prevailing Wage Act and everything that we presented in our slideshow today.
Thank you, Brian. The next question, if there are work lapses on the project, do certified payrolls need to be submitted for those non-work hours?
Yeah, great question. And sort of those technicality questions like this. Listen, if you didn't work for 2 weeks and don't submit, there might be questions that get posed like, well, did we miss these payrolls? So do this, put on no work and submit. That's all. That's all you got to do. You don't have to worry about filling it out in detail. Just the week of whenever no work took place, no work, done, type it up, put it in marker, however you want to do it, and then submit that, and you're perfectly in compliance by doing that.
All right, here's a clarification question. Did I understand correctly that a salaried supervisor who's on a job site and works 5 or more hours should receive prevailing wage for those 5 or more hours?
You did. Thank you. I'm glad that you listened. Yes. So if I'm a supervisor and I do no work at all, but today there's a need, Bob called in sick. Sally's not here to run the backhoe. I got to jump in. I'm now performing work for 8 hours today. I'm appearing on a certified payroll form. And despite the fact I'm a supervisor, an employer now must make sure that I meet or exceed the prevailing wages when you get the hourly rate from me for the work that I've done. But yes, it's important to note that any working supervisor, they need to appear in a certified payroll form and be paid for that work.
Thank you, Brian. I think you may have answered this, but I'm going to read the question again. If we are planning a project spanning multiple localities, can we submit one request encompassing all localities, or do we need to submit a request for each locality where we plan to build?
So again, here's my most practical advice to that person, and that could be a call to me or an email to me after this in which we can talk more. Here's my most practical advice. If you're only in Dauphin County and you submit your wage rate determination, but in the notes you put down, we are in multiple locations in Dauphin County, we will probably call you up and ask you where, okay? If you are having a project in Dauphin, Northumberland, Franklin, Schuylkill, multiple counties, be safe. Put a request in for each county. And if we in turn have to reject one, we'll do that, but we'll explain why. But normally and typically, so there's a benefit to the folks in this call who are doing the highway work. A lot of the differences on locality rates are found mostly in building work or in residential work. So count some blessings on that. You don't have to worry as much with the highway work as you would with building work. But be cautious, make sure you're getting the right rates, make sure you're getting to us the locations. And again, make note in your determination request that you're typing out of the different locations that this is at. And we in turn will look at that and we read these things. We make sure before we issue rates that we're doing it for the right county and the right locality. So that would lead to maybe a question to you or maybe an email to you. But if it, again, the big picture, if you're only in one county, do one request. If you're in 5 counties, do 5 requests, and we'll take it from there. And we'll either issue all 5 to you, or if there's a need to only issue 2 or 3, we'll do that. But I think it's important that we kind of have as much early information as we can. That way we avoid any potential mistakes or anything that we might miss a year from now.
Okay, thanks. If we are a subcontractor and the prime contractor hasn't received a determination, what is our requirement to be in compliance?
Could you read that one more time? I think I missed the first part. I'm sorry.
Sure. If they're a subcontractor and the prime, I'm guessing maybe prime contractor hasn't received a determination, what is our requirement to be in compliance? What's the subcontractor?
It sounds like we have a problem. Without naming names, I received a call on Monday, and the call on Monday was actually a contractor who's bidding on work of this nature right now. It was labeled a prevailing wage project. It's out for bid now. And the contractor said to me, "Hey, can I put a request in for prevailing wages?" I said, "Well, you didn't get the award yet, right?" "No, I did not get the award. It's just out for bid." I said, "Well, then it really needs to be the telecom company in this situation that puts that request in." So luckily in this circumstance, we were able to connect with the proper person and a determination was put in. The problem there would be this. We create an unfair bidding issue. If only one contractor puts a request in for prevailing wages, but 5 others are bidding on it, only one will know what the rates are. It should be coming from the telecom company or from the grant recipient. That's who should be doing the request for prevailing wages at the very beginning. That way, when it's put out for bid, there's no mystery. Everyone knows this is what the rates are for the work. I could come up with saving costs on the material. I can have less overhead, but I know as a contractor, these are my rates. There's no mystery there. And that creates the equal playing ground for anyone who bids on that work. So it needs to be done first and early, and it needs to be done by the telecom company. If anyone out there discovers that it has not been done, reach out to us immediately and we will talk to whoever we need to.
Thank you, Brian. The next question is there a general frequently asked questions document or website already created for broadband specifically, CPF and BEAD? Brian, I'll take that question.
Okay.
We are in the process of developing that. We do have a current website, and we will be putting information on that website for you as well. There will be a general frequently asked document created after this presentation.
And I'll also add to that, Steph, we have a general frequently asked question page for prevailing wage that doesn't work right now. But yes, it's also on our website. Oh, the prevailing wage rate. I might be able to, before we're done, I think our website just popped up. So we'll go through the questions first. And if there's still time, I can show what we've been talking about.
Okay, great.
Thanks. Both of you. Next question is, looks like are drafters and designers not on the job site, but working behind the scenes subject to prevailing wages?
No, and they probably get a lot more money than the workers on the job site. They are not. Those who do work on the actual job site itself. So anyone who's doing the design of that project, any of the people drafting plans, any of the people who are at a desk doing something of that nature, they're not doing labor on the project, they're not covered. Might be different if you're doing on-job surveying, that's covered. Or if you're also doing any work that requires you going to the job site. We see this a lot in building jobs. Electrical workers go plug in a device, they plug their laptop in, and now they have to repair things that may not be running correctly. They take the screwdriver, take stuff off walls. That's covered work. But anyone drafting, any designers, any project managers behind the scenes drafting up plans for it, they're not subject to prevailing wage if they're not doing work on the project. On the site, job site. Sure.
Thank you, Brian. We have one more question. Are utilities regulated by the Public Utility Commission exempt from prevailing wage requirements? For example, Comcast, Pennsylvania, etc.
I'm not aware of any exemptions. We've written opinions before. Let's go back to what matters here. Done under contract. If one of those entities is contracting to do work on a job site, that's probably going to be a prevailing wage project if it's state funded at more than $25,000. And also too, if Comcast, Penelec, or whomever else is, maybe subbing out their work to a contractor, you still have a prevailing wage requirement because we have something being done under contract. So
we don't have any more questions.
All right, let me just go. I'll go through this quick before it doesn't work again.
Okay.
So Let's hope it works, right? Here's the big moment of truth. All right, so we mentioned before, here's our website, right? That search bar is back. You can type in prevailing wages here, right? I'm not going to do that though. I'm going to go to services. I'm going to go to labor law compliance. We're going to then go to, and by the way, I would advise you to look at all of this, and I'll tell you why. Child labor. We're seeing a lot of child labor violations in construction lately. We're seeing a lot of Act 72 violations lately in construction, which is misclassifying someone as a contractor when they really should be an employee. So all the information on here is beneficial to any contractor doing work in PA. But let's talk about what we're discussing today for Pennsylvania Prevailing Wage Act itself. All right. So on this page, we're going to find, crossing fingers. Okay. We mentioned before, prevailing wage FAQs, debarment list. These are contractors who should not be getting state jobs. Information for that Pennsylvania Prevailing Wage Advisory Board, information about the regulations, a prevailing wage complaint form. Also on this page, we have online prevailing wage application and rate search. I'm going to show you that in a moment. But down here, we have prevailing wage quick links. People have been asking questions about the traffic signal person or electric lineman. So let's go to the prevailing wage quick links. And when we click on this, we will scroll down. A lot of good information. Here's your prevailing wage poster. Here is your prevailing wage awarding agency form. Here's your certified payroll form that you can fill out and print this and submit that weekly. Down here, we have complaint forms, but here's all the notes available. So remember I mentioned before, we have 29 county notes, 7 county notes, 33 county. Don't be scared by that. Let's just look at it. Let's go to the notes for the 33 county heavy and highway laborers. When we click this, there's either a PDF or the web version. When we click on this, the 33 county notes are now explained. It tells you the exact counties where these notes are in reference to. It will then give you details of what classifications each laborer consists of. So we have a lot of different tools listed down here, all the different classifications, which, by the way, coincide with the rates that you get for these counties. You're going to see labor class 1, labor class 2, labor class 3. And you're going to say, what does this mean? Go to our website and you can see what these workers are doing that would constitute that type of labor work. Let's go back for a second. And I mentioned before, again, we have definitions for operating engineers. We have definitions for electric linemen. Oh, one thing to be very careful on. Notes for 29 county building construction common labor. Don't use that if you're not in a building. You would use the definitions for the 29 county heavy highway construction laborers because we're talking about outside work. That's extremely important. There's 2 different notes for 2 different types of work. Up here now, we go to our prevailing wage rate determination request. Okay, I do want to mention one thing. So remember I mentioned to you before that rates that we give out are good for 120 days, unless it's, and if it's not contracted, a new rate determination needs to get done. So you might say to yourself, well, what's the use of me doing a rate determination today if I know the bid's in December? You don't have to. What you can actually do, and we'd advise this, you go down to our prevailing wage rates determination search, and let's say your work is going to be in Adams County. All right, we just click on Adams County on here. Don't put anything else in at all and hit search. It will bring up any job that's taking place in Adams County and will give you the rates for that work. So let's just pick a random project. We'll click on this. We turn our paging off. We turn paging off because then it's all listed on one page. And we scroll down and we see every potential rate that might be on this job. Now we know that this project is a building job because we gave that classification up here. So if you were doing work on this project, you would look to the building section and all the rates in here would be what you would pay attention to. On the other hand, if we would say highway or heavy, you would go down here and you would look to the rates down here. So as mentioned before, you might have a circumstance where you don't have this project out for bid yet. You know it's going to be well over 120 days from now, so there's no need to do the rate determination yet. But if you want an idea of what the rates might be, search the most recent job we gave out. Because it will show you, for example, cement finishers, 48 an hour. It will show you electric linemen right down here. And you might be confused by seeing 2 dates. Why do we see 2 dates? Why does the rate for electric linemen go from $51 to $52 an hour? Because we have what's called an escalator. That means on June 3rd of this year, any electric lineman, if they're making 51 bucks an hour on June 2nd, by law, they now must make 52 an hour on June 3rd, because that's called an escalator. So this site will also, any of the rate determinations that you get back in an email will also be listed on this website. So if you don't get your email and you panic, like, oh my goodness, I know I put in a contract for the Spangler Farm Trail, but I never got my email. Check our website. Chances are it's there. And in this circumstance, if you were the Gettysburg Foundation, it would be there, right? And see how this is how spelling mistakes happen. And this is not to criticize the Gettysburg Foundation, but this goes to my point before. Foundation spelled wrong here. Mistakes happen. We cannot change what you submit. If you submit something with incorrect spelling or an incorrect email, we can't change it. We could call you and say, hey, if you want this to be correct, you might want to reconsider and do another one. But whatever you submit, when you hit that button and it comes to us, it's done. There's no changes we can make, because what you're submitting to us is what you're saying the work is. We don't alter that. It's what you're saying the work is. It's a very important thing to know. So watch your spelling, find your P's and Q's, but make sure your email addresses are in there correctly as well. That's all I got.
Thank you, Brian. And we only have one more question left.
Okay.
It's from Patricia. What about service contracts after equipment is installed?
Great question. So are we talking about if there's any mechanics on equipment during the prevailing wage project, prevailing wage covers construction workers and mechanics. So if a rate's over 5 years from now, someone has to come back and fix something, and it's not going to be state grant funded, that's different. But during the course of the job itself, if there's a need to have someone come back after equipment's installed and have a contractor perform work to fix something during this project, that would be covered by prevailing wages. I saw one question here about the copy of the presentation. Steph and Brandon, what's the best way? Should I get this to you and you can circulate amongst the group that is on here today? How would you like me to do that?
Yes, Brian, please send it to us and then we will send it out to our listserv.
Okay.
In addition to that, a copy will be on the website along with the recording. Brian, you've done an amazing job and thank you for this information. Thank you to everyone that has attended today. If you have questions, the resource account has been placed in the chat. Please feel free to reach out to us. We will be providing this information online as well as providing you with it via email. Thank you, everyone, and have a great day.
Thank you, everyone. Have a nice day.